What happened? The move.
The order of the
Motion.
women.
To be mentioned today.
Then Monday,
What is the matter?
challenge the order of the eviction.
Eviction order. Oh, so you are for the tenant or licensee.
Severe appears in this matter.
So what is your prayer?
Today we had five.
To be mentioned tomorrow, not Monday, and inform the other side. WPA. So who is for the petitioner? 186.
Actually, similar matters, Your Worship, there are certain orders in a similar matter. What I am praying, Your Worship, let this be on Monday, so that I can place those similar matters. Orders in those matters.
So you have filed one certificate that to whom it may concern. Yes, there is a certificate only in respect of Sushanto Pramani, but there is no such certificate in respect of other petitions.
But
There are
documents are there, Your Worship.
bank statements.
Here, Your Worship, the police department.
So do you want to file any affidavit in opposition or anything?
Well, we can file
Or short affidavit?
and file affidavit in opposition, but we are on the point of retenability.
Oh,
Because we are saying that this matter, so we have 6 to 7 points that this matter is not maintainable.
okay.
And those matters on which our learned senior from other sides relying on, those matters are made silent and based upon the decision of the Supreme Court, which outcome is pending today, Malad. That's ONGC judgment where Malad, Supreme Court is Malad, currently the situation is pending. Supreme Court is on the first to decide that which bench has power to hear the regularization matter. Either the regularization should be heard by a labor court or it should be heard by the High Court, because here the prayer is regarding first prayer is 1/50, second prayer is regularization.
So Uma Devi is there.
No, but they are seasonal workers.
Oh, seasonal work.
The seasonal worker, Uma Devi does not talk about seasonal workers. And the regularization also, even if Uma Devi is there, then also then has to be taken out either by the High Court or by the Labour Court. So who is competent to take decision in regard to the regularization? Because if Labour Court will be competent declared by the Supreme Court, then we will take that plea that then they first has to go to the Labour Court.
Okay.
All these
Based
things,
upon certain decisions of
all these
So-
things,
Yes.
all these things were looked into by this honorable court in a similar manner. And as in this case also, and in that case also, the petitioners were apprehending termination, illegal termination, so that the Honorable High Court has protected the petitioner by saying that before doing so, 10 days prior notice should be given. That
Whatever it is, you have said that your service will be terminated before 1/4/2025. Today's
No, I am saying that service already been terminated.
Terminated. Oh,
That I am saying.
Let it be on Monday, Your Worship, I'll take it.
there is Monday huge pressure.
Yes,
Tuesday.
yes. Because this also has to be tagged along with those matters.
Yes, that can be done, that this matter can be tagged with those matters, but let it be come on Tuesday.
Tuesday, they can.
To be mentioned or new
Yes,
motion.
New motion.
New motion under the same heading. The learned counsel for the parties have sought for an accommodation. This is the matter under appropriate heading on Tuesday title. Three matters, I think. No,
No,
only one matter.
Only one.
Oh, okay.
Item number.
What? Item number 1. Next.
Here, Your Worship, what happened? There is
Now, who is for the other side?
APW. APW.
Who is for the other side?
Your Worship,
if it will be for others, I will use the, we shall take instruction, we have not received the.
Actually, the problem is that, Your Worship, what happened? Tender notice was published. Now, in the tender notice, it was mentioned for supply of.
4-star and 5-star.
Yes, Your Worship.
4-star and 5-star.
For start by.
And Rajnivas is one and another protocol of office.
Yes.
4-star.
How can
Did
they
not, did
ignore
not,
that,
ignore it. This-
Well, look into this, we'll ask from the department what is this, because I.
So you take the notice,
File.
Yes,
Yes, yes, I can
Monday
take
because they may award the contract. Till now, the contract has not been awarded.
but I have to hear,
Once
if I want to pass any interim order, I have to hear
Yes, Your Worship. Let it be Monday, Your Worship.
the learned
Ah, let
counsel,
it be Monday.
the learned counsel for the. Now, Mr. What is your name, sir?
Dinesh Dwivedi, I'm led by Mr. Chakraborty.
Mr. Dinesh Dwivedi
Dinesh Dwivedi, then moment.
has submitted that he will take instruction from the department and will come back with proper instruction on Monday. So, this matter. তার আগে একটা in between the learned counsel for the petitioner is requested to hand over
One copy of it. I'll give
the
one
copy of the petitions along with annexes to Mr. Dwivedi. ঠিক আছে, এটা মাঝখানে
Next one is similar.
same. Okay, same order. Monday.
Monday.
Great.
I think 4.
There are one of them.
No, next week. What is CRF?
Thank for the response.
What is the case?
Worship. They have filed a petition under section 227 for discharge of the accused petition.
What is the stage in the trial court?
That is for a charge. Discharge petition.
So
was
discharge
rejected.
petition was rejected and
Rejected.
okay.
That has been changed.
Now, what is the reason for consideration of charge? Why this stage has been settled by criminal procedure court?
Worship.
Because at the time of consideration of charge, the accused can show that he is to be discharged.
Lordship, there is a provision CRPC Lordship 227
So in
for
the
discharge that if there is no evidence at all from the
Yes.
place of the charge.
exactly.
So for framing of charge Lordship, only prima facie evidence has to be established by the
Exactly.
prosecutor. Exactly. Then thereafter, the commencement of the trial. Here, the argument of the petition is that there was no evidence against this petitioner because he was charged under section 7 and 13 of POC Act. What happened, Lordship?
POC Act means?
Prevention of Corruption Act.
Oh.
What happened? The petitioner was the junior engineer. Some construction was given to the private parties. The junior engineer petitioner was looking after. There are 5 persons in the elaboration engineering units. All the 5 persons, accused persons were tagged in the charge sheet, and charge sheet was filed against that 5 accused persons, including this petitioner also. Allegation is that the construction of some culvert in one village was executed, and these persons with connivance with other contractor, some misappropriations of money.
Defalcation.
Yes, some misappropriations of money, 120B conspiracy was there. Then some procedure aspect was not followed by the engineering wing, and that culvert was collapsed. Culvert was closed, 2 to 3 children were expired. Thereafter, inquiry was conducted. On inquiry, it was found, yes, due to the some mistakes and for some not following the rules during mixing of the materials. These all 5 persons are responsible for that act. For that is it, after conclusion of the inquiry, FIR was chalked out, then charge sheet was filed against 5 accused persons.
And they are in custody or?
They are on bail.
They are on bail. And now delaying the.
No, it is fixed for framing of charge. 227 already discharged, and speaking order was passed by the trial court.
So, madam, tell me, what happened? Who are your senior? Who is your senior? Gopala Bindu. Is there any difference between G. Bindu Kumar and Gopala Bindu Kumar? Same. One and same person. So, pass over for 5 minutes. Okay. আচ্ছা এটা পাস ওভার করে রাখুন, পাস ওভার
This was in the failure of this.
Yeah, for the private.
Yes,
Fine.
you're private respondent.
I for the states.
Now, and Mr. Gopala Bindu Kumar is for the citizen. What is the case about?
That's tell us. CR case was registered. Someone was issued. That is the petitioner.
Huh.
That has been challenged.
No. Someone is issued, cognizance is taken, he is on bail. Thereafter he come for challenging the cognizance.
Oh,
He is on bail.
so he has legal rights to challenge any order passed by the court. So, what is the order which has been challenged? The page number?
In 3/2023 Lordship.
No, page number.
Page number, Lordship. 85, Lordship, page number 80.
Next week,
No,
I want to see that so that I can prepare myself.
page number 85, Lordship.
85.
Order number 7, dated 14/6/2020.
So you are the de facto complainant of complainant. You are the,
Lordship, I am the complaint.
that's right.
Brother.
85 or today is fixed for further essay. Complainant is present. This order,
Lordship,
along with one, namely Golok Bishwas, he is examined.
under section 200 says.
Complaint along with
State with the report.
on
There is
basis
the
of the-
complaint along with the one other material on the report as well as the statement of the complaint and the witness recorded. One is on perusal of the complaint and the position recorded under section 200 says along with the document filed with the complaint, it appears that there is sufficient material for taking permission of the office.
Yes.
The process issue, Lordship, he appeared,
Hmm.
turned up before the honorable court and he took bail and contested the case.
Hmm. So what is the ground for challenging that order?
Okay.
Subsection of that.
Order
Last
of-
petition submitted before this court.
Yes, I have forgotten. It's a very short memory.
Also will be-
Yes. Okay.
Regarding cognizance, Lordship, exact meaning cognizance is not in IPC, CFPC. Cognizance is nothing, it's judicial notice to the court regarding the offense only.
Yes.
Do not receive
Regarding only offense.
satisfaction on the part of the.
Yes, password for short password. Yes. I said, for you take up the other matters before you call 7. Okay. 7টা পরে ডাকবেন, আগে অন্যগুলো আগে করে নিন। ও 6 আছে না? 6. Who is for the other side? Oh, please allow Mr. Kumar to come. হ্যাঁ, পাসওয়ার্ড করে রাখুন। এইগুলো সবগুলোই পাসওয়ার্ড এনে নিয়ে 7টা একটু পরে ডাকুন, অন্যগুলোকে নিয়ে নিন।
The report has come back.
Yes, see. Report 5 is report. Yes. So what is your prayer now?
Better order. Set aside.
Set aside. No, not set aside.
It's not prayer.
The member secretary, just a minute, the appellant shall. The member secretary, state authority, court shall appoint an advocate from the panel to represent the respondent in this appeal. The department shall make available copies of application links to the learned counsel to be appointed by the state legal service within a week from date. This order shall be communicated to the member secretary.
Nobody has come.
No. Whether this member secretary has been intimated, whether he has appointed any, that report should be here.
Let the report be confirmed.
Yes. The learned counsel for the petitioner,
My lord.
appellant has submitted that as per direction of the court, he has deposited the entire awarded sum with the register circuit bench of Calcutta High Court at Port Blair. Stop. The learned register has submitted one report stating that an amount of rupees 3,54,520 by check number 727796 dated 27/3/2025 has been deposited by the appellant, and the same has been with the current account of the registry. Stop. Para. In view of the order dated March 13, 2025, the order impugned the operation of the order, which was the order date. Order dated 12/6/2023,
12/6.
passed by the Motor Accident Claims Tribunal within bracket Additional District Judge at Port Blair in MSCT case number 21 of 2015 shall remain state. Stop. Para. It further appears from the said order that the member secretary, State Legal Services Authority, A&N Island, Port Blair, has been directed to appoint an advocate from the panel to represent the respondent in this appeal. It is further directed that the department shall make available copies of the application and the pleadings to the learned counsel to be appointed by the State Legal Services Authority within a week from date. Para. None appears from the Legal Services, State Legal Services Authority to represent the respondent as per direction of this court. Stop. Para. The member secretary, State Legal Services Authority, is requested to submit a report whether the said direction has been complied with or not. Stop. This is the matter on Monday.
Yeah.
Inform. Need a copy of this order should be received. Okay. So that order has been stayed.
My lord. Deeply.
Monday. Monday. Yes. So every time you are seeking for Passover, second half. Okay. So who is for the other side? Sumit sir. ঠিক আছে, এটাও পাস ওভার হলো। পাস ওভার। হ্যাঁ।
It's a 6 of 24.
Your Worship, I am for the appellate, Your Worship.
So who is for the other side?
Mr. Arun Prasad appears for the reason.
Huh?
Mr. Arun Prasad appears for the.
No, there is nobody. So not today, not today. তারপরে কি আছে?
This is a very short matter, Your Worship, this can be discussed.
FM 11.
Yes, whether in an MSCP case, in these islands, ad valorem court fees has to be paid. Yes, when there is no provision either under the act or under the regulation.
Now we want to hear Mr. Chakraborty. I think.
Yes,
Yes.
I'm for the private respondent.
Yes. Why is Mr. Chakraborty?
No, I'm for the private respondent.
I understand.
Mr.
We want to hear the
Sadhu Sahib, who put my-
direct counsel from the government. That was our.
yes, Your Worship.
So if he is available, okay. Otherwise, in the second half.
Because
Okay.
we have been, I have been practicing for last 28 years.
Yes.
And my learned friend also same years. And
Yes.
we know that we have been paying at least 20 only. Suddenly, Your Worship, this thing has come. So we were also astonished that on what basis the court is fixing ad valorem.
Even I support the case of petitioner, my lord, because we also practice similarly on the same field. So we never used to pay any court fee apart from fees 20.
It is only on the basis of the court fees act application, heading application. So
So
under the,
let Mr. Chakraborty come,
Yes.
then we decide. Otherwise, in the second half, it will be taken up. Okay. Next.
you should let it be on Monday, Your Worship. Second half, I have some difficulty.
Okay, not today.
Oblige, my lord.
Later. FMT 12. এবার 7টা এটা দেখে দিন, এবার 7টা দেখে দিন। Yes.
Yes, Mr. Shatabdi has.
My apologies, my lord.
So now, 12.
Lord, we are yet to receive my lord instructions.
Why? So this
Just
is,
show if there is any act of regulation governing. this.
so ad valorem court fees are being, you are paying ad valorem court fees.
Now we have been directed to.
By the,
Earlier not. Earlier. I
So
thought-
what is, why is the order against,
Yes. Your
order
Worship.
dated?
Yes.
My lord, may I have it on Tuesday, my lord, we'll take instructions.
I want to understand the question.
Yes.
What is that? 24 to 2025.
This one. Your Worship, 24th February 2025.
Yes. It appears from the record that proper court fee has been assessed and that is to the tune of rupees 7044, out of which only rupees 20 has been paid by the claimant. Only 20.
It's under application. We don't have any separate act governing the application.
West Bengal Court Fees Act is not.
Not.
no, it's not applicable here, my
It's not
lord.
applicable.
We have a separate,
So,
No, my lord, the way, my lord, it has been seen as, my lord, at where, my lord, it is not prescribed, my lord. There, my lord, ad valorem is applied. So, my lord, in this case, my lord, they are treating it as an application.
No.
But, my lord, their contention is it should be treated as an application. But our contention, my lord, it should be
the
treated
original
like a suit.
application.
It should be
Original
treated like an original, it should be treated like it is an original proceeding. Actually, it is an original proceeding. So it has to be treated like a
Under
suit.
such circumstances, why the West Bengal is applying the particular provision for calculating the court
court
fees?
fee.
Why the suit court?
How the calculation is to be done?
Ad valorem, my
Ad
lord,
valorem they are telling you.
it has to be ad valorem.
No, it cannot be.
But my lord, if it is
That is
ben-
not the judgment.
It's
Act.
a beneficial legislation, my lord.
appearing for the administration, my lord, in this case, I'm appearing as officer of the court, my lord.
Yes, yes.
I certainly appreciate, my lord, that hardships to litigants also will be there. But my lord, I need instructions in proper instructions. Let it come on Tuesday, my lord.
আচ্ছা, এটা লিখে নিন।
If we are not able to produce,
The learned-
my lord will pass on.
the learned counsel for the petitioner as well as the learned counsel for the private respondent are present. Stop. It appears that a legal issue has been arisen regarding payment of proper court fees in the cases before the MACT tribunal. পুরো কথাটা লিখে দেবেন, MACT tribunal. Stop. The order number 76 dated 24/2/2025 passed in MACT number 01 of 2014 has been challenged by the petitioner. So, according to the learned counsel of the petitioner, the petitioner is entitled to pay ₹20 as court fee instead of ad valorem court fees as assessed by the court. Stop. She has further contended that provisions of West Bengal Court Fees Act has no manner of application in this island. Stop. Para. This court requests Mr. Shatodru Chakraborty, senior advocate, who used to appear on behalf of the administration in several cases, to take instruction from the concerned authority and to assist this court to adjudicate the instant proceedings in accordance with law. Stop. When? Tuesday. Please the matter. Okay. Supply copies of everything. Mr. Documents or something like you want.
Yes, yes, already informed, I'll get to that.
এবার 7টা রাখুন, 7টা।
Your conference.
Yes. এটা কি? এটারই তো না, এগুলো ঠিক আছে। I think you have mostly completed.
Almost just few paragraphs I wanted to show thereafter.
The limitation point.
Yes, there is no doubt about the fact that I have the right to take the point of limitation, relinquishment, waiver and excesses. I have a right to take that one. For that, I should have some basis. No, Your Worship, I just wanted to show those things. Kindly come to Your Worship. Page number 70 of the paper. Page number 70.
Yes.
Paragraph 5. Certain paragraphs I wanted to show you. That I have
Hey,
taken this.
just a minute. It is the paper book, no? Where is the paper book? They all make it. Oh, sorry. 70. Page number 70. Yes. What is this? In the court of the civil judge.
This Written statement filed by us.
There's a 71 is certificate.
Page number 17, Your Worship, 17.
Oh, sorry. 17. Yes.
Paragraph 5.
Paragraph five.
That with reference to the contents of paragraph 5 of the claim, it is admitted to the extent that late Suren Das had during his lifetime arranged for the marriage of his daughters. It is further submitted that Satyavan Das, the plaintiff number 1 herein, started residing separately since 1969, and the husband of the defendant number 1 was residing with his father, late Suren Das. The father of the plaintiff during his lifetime never expressed his will to divide the property among the plaintiffs and Motilal Das. Then, paragraph 7. Just to project that, I have taken the point of relinquishment, relinquishment, waiver, acquiescence, and limitation. Page number 18. Paragraph 7. That the contents of paragraph 7 of the claim, the same are denied in this period. It is further submitted that plaintiff had wrongly stated that Suren Das died in 1977, whereas when Suren Das died, the plaintiff were never in joint possession of the suit property along with the defendant number 1. Satyavan Das had relinquished his right over the suit land in 1969 when he left his father, late Suren Das. Then, paragraph 11, page 19.
Now, Sri Satyavan Das had relinquished his right over the Suk land
Yes.
in 1969. How it is possible? His father died in 1973.
He left the property and went away.
No. I want to know from you, madam. He left the property in 1969, and Suren Das died in 1973. So, at that point of time, he was not a owner.
Not an owner, but whatever.
How he can relinquish his right when he,
Your Worship, I accept Your Worship. But our condition was that he left the father. He
okay,
went away.
that point can be, but relinquishment by yes.
Then paragraph 11, Your Worship. That with reference to the contents of paragraph 11 of the said claim, it is admitted that after the death of Motilal Das, his wife had applied for mutation of the suit land in her name, and after receiving the notice of mutation, the plaintiff raised their objection in writing. It is further submitted that suit land is not the joint property of the plaintiffs and husband or defendant number 1, as the plaintiffs had relinquished their right over the suit land, and at the time of mutation of the suit land in favor of Motilal Das, the plaintiff never raised objection, and now in order to grab the suit land, with well-founded intention, had raised the objection for mutation of the said suit land in favor of defendant number 1. When the land was mutated in the name of Motilal, as they have relinquished their rights, there is no objection when the mutation took place. And after when Motilal died, when the defendant number 1 applied for mutation, they started raising objection. Our contention is that they ought to have raised the objection at that relevant time. My point was that
Only limitation.
only limitation. And relinquishment is also there because this is our case.
Waiver acquisitions.
Yes, waiver and acquiescence. They waived their right. This happened in 1985. Suit was filed in 2000 after 15 years. Now, one more paragraph was added. When the suit was pending, one more paragraph was added in your Lordship. Kindly come to page number 22. Paragraph 8. The defendants herein intends to amend the written statement by way of inserting one paragraph. This amendment was allowed. That Motilal has executed a special power of attorney in favor of plaintiff number 1 on 20th May 1986 in respect of the land bearing survey number situated at this, and the same was duly registered before this. Yes. As he was the owner of the property, he executed a power of attorney in favor of plaintiff number 1 to look after the property. Even at that time, there was no objection. Then the amendment.
So Satyavan is the plaintiff number 1.
Satyavan Das is the plaintiff number.
So he is the brother of Motilal.
Yes. Brother of Motilal. 2 daughters, 2 sons.
Yes,
Motilal, Satyavan, 2 sons. Ranjita Baladas, Lucky Rani Das, 2 daughters.
yes. Yes, tell us.
No, yes. Even if when the Satyavan Das was cross-examined, this is at page number 35.
35.
Yes, 35.
Hmm.
Second paragraph will say, I encroached separate government lands during the lifetime of my father, and the said land was duly recorded in my name, and accordingly I started cultivating and possessing the said land. Why I am stressing upon this point?
No, it is in cross-examination.
Yes, cross-examination.
Para number?
35,
Huh?
cross-examination, second paragraph.
I encroach separated.
I- Here in these islands, as per the schemes, if I have a landed property or my ancestors have landed property, the land will not be recorded in my name. The encroached land will not be recorded in my name in terms of the 1987 scheme.
1970 scheme.
1987 scheme.
87.
It says that whoever occupies a government land prior to 1978, that particular land will be regularized in the name of that person, provided his father or anybody of his immediate ancestor, they don't have the property in their.
Yes.
Now, next is,
Now, whether this regulation has the power to override the Hindu Succession Act, I want to know. As a newcomer in this island, so I want to know from all of you.
I am not on that particular point because here we are not the owners.
Yes,
Hindu
sir.
Succession Act is basically applicable where ownership is vested with the person. Here all of us are licensee. We are not the owners. Those certain rights are given to us, but we are not the owners.
Yes, but that is true. But how then? How you are selling your land?
It is provided under the regulation. In terms of the regulation only.
So
we are
that
saying-
right to occupation,
Yes,
right to occupation is being sold.
yes, yes.
That right is to be sold. So I don't know.
Several restrictions are there. It's
So
not
right-
so simple.
So right to
If I
property.
want to sell a house site, I have to obtain permission from the deputy commissioner. If I want to sell an agricultural land, there is a limitation. And over report is called from the tehsildar. Several restrictions are there. It's not simple as like that of naming, because their ownership is there.
Hmm.
Now, the loan which was then loan, I mortgaged this land and borrowed loan from the bank. That document has also been exhibited.
There is a judicial decision by Honorable Justice Alok Kumar Chakraborty, Kumudaranjan Kaur versus Bimala or something like that.
Yes.
Do you have any knowledge of that?
Sisarama Devi,
Yes.
judgment, that Kumudaranjan.
Whether these are,
Yes, probate is not required in these areas.
so I want to see that decision also.
Yes, I will provide. Probate is not required in these areas. Sisarama Devi and Kumudaranjan Sajjan.
Okay. Loan was taken after mortgaging this property.
Yes,
And he stands surety.
yes. No, Your Lordship, I am coming straight to the decision, Your Lordship. Because all other documents have been exhibited, even the power of attorney was exhibited.
Now, how if he is not an owner of the property, how the mortgage can be done? That is
It
the
can't
route.
be, Because mutation took place, they never objected, they relinquished their right. It was mortgaged in my name and that it was mutated in my name. And on the basis of that mutation, I mortgaged the property, I borrowed loan from that.
Now,
Everything was within their
if
knowledge.
you are not the owner, then bank cannot grant loan.
Cannot.
But here bank granted loan to you.
Because the property was mutated on the basis of the relinquishment done by them. There is no objection. Here, Your Lordship, when mutation, Your Lordship, in mainland, Your Lordship, so far as I have a little knowledge about it. When a sale deed is executed, when you want to get it in the record, that particular fact in the record of the revenue department, you have to just place the sale deed. The authorities will verify and it will be carried out. The process will be carried out. Here, the procedure is not like that. When we file an application for mutation, Form J is issued, whereby objections are called. If suppose objections are not there, then Form K, again one form is issued. So that if anything is left out, then in that case, that can be corrected. Even at that time, there was no objection. And thereafter, mutation took place. I will be relying upon some of the provisions of the regulation. Then, the documents, all documents have been exhibited. The exhibit document. That's the regulation, that's true.
So 1987 scheme, I want to see that provision.
Yes, sir.
That if anybody occupies a land,
Yes.
then the land of his father will not be recorded in his name.
And I have been paying the land revenue since the date of my mutation. Your Lordship, if they have a right over the property, at least some attempt should have been made by them to pay the land revenue.
Yes.
Why there was no attempt? I was the person who was paying the land revenue.
Yes. Dependence, no?
Yes.
Anything else? I think you have completed.
I'm just want to show the provision.
Yes.
The special power of attorney has also been exhibited as exhibits F.
Mm.
And my submission is that if your Lordship would peruse both the court's judgment, this point was not at all taken into consideration, neither adjudicated. Both the learned court. When my specific case is about waiver and acquiescence, relinquishment, limitation, these things ought to have been adjudicated. Why there was requirement for me to exhibit the issue relating to mutation, the power of attorney, the loan, the payment of land revenue.
Mm.
So my submission is that this is a fit case of remand because these things have not been taken into consideration by either of the two.
Okay.
Your
So,
Lordship, I am relying upon a judgment of the Honorable Supreme Court, and there I will be referring to the provisions also.
yes.
Your Lordship, thank you. This is reported in 2019, volume 12, SCP 452, paragraph 37.
Yes.
Paragraph 37. On the basis of the will, mutation took place. Now that was challenged. And then, now I'm reading it. In the impugned judgment on the High Court set aside the decree dated 11/9/1997 of the district judge and that of the learned trial court dismissing the suit of the plaintiff Presto in Imperial Judgment, High Court also there is a question of limitation. The High Court observed that learned trial court, while recording the findings under issue number A, has held the suit to be not within time. No findings have been recorded by the learned district judge on the question of limitation. Considering the pleadings as a whole as set out in the claim, the suit of the plaintiff as laid on the face of it was not within time. There were neither pleadings nor evidence as to the date on which the plaintiff had derived the knowledge about the limitation and ordering. Because when I have taken a specific point that into 1985 limitation took place, there's no dispute to that fact. Why after 15 years they approached the court? No justification, no adjudication. So here Your Worship, the Honorable Supreme Court has said, both the trial court and district court did not deal with this aspect of limitation in proper perspective. The High Court in our considering has given correct findings regarding limitation. We have carefully critically examined the findings of the High Court on the issues of date and its consequent limitation. The findings are based on correct evaluation of it, and thereafter Your Worship. Now, Your Worship, I am referring to certain provisions. Your Worship is having the regulation.
Hey, regulation. Regulation, yes.
Now, Your Worship, we finally come to regulation 89.
Regulation 89.
Yes.
Hey, 89, this is 1966 and 1968. What is it? 1989? Eta কিনা দেখুন তো এখানে আছে না 1960 1966 and 1968.
Yes.
Yeah.
State is the rules.
So you want to show that 89,
No, 66.
66.
Regulation 66, regulation 89.
Okay. If any revenue officer.
If any revenue officer finds that a wrong or incorrect has been made in the land records prepared under section 88 by an officer subordinate to him, he shall direct necessary changes to be made thereafter, making such inquiry from the persons concerned as he deems fit after due written notice. Thereafter, 91. If any person is aggrieved by any entry made in the land records prepared under section 88 in respect of matters other than those referred to in section 83, he shall apply to the revenue officer for its correction within 1 year of the date of such entry. The revenue officer shall, after making such inquiries, he may deem fit pass necessary order in the matter. 91. Every entry in the land record existing at the commencement of this regulation and every entry made therein under this chapter shall be presumed to be correct until the contrary is proved or a new entry is lawfully substituted thereon. Then, yes. Every person whose right, 91. Every person whose right, interests, or liabilities are required to be or have been entered in any record or register under this chapter shall be bound on requisition in writing by any revenue officer engaged in compiling or revising the record or register to furnish or produce for his inspection within 1 month from the date of such requisition all such information or documents needed for the correction, compilation, or revision thereof as may be within his knowledge or possession or power. Now, Your Worship, that's why I am reading all these things. They have come to the river, the parties, to the mutation proceeding, they have raised no objection. Now, if they wanted to get it corrected, mutation happened in 1985. They wanted to correct it. These are provisions are there. They could have approached the authority concerned and said that these corrections are these entries are incorrect. So this is to be recalled and a new entry has to be taken place because we have never relinquished our share in favor of Satyabanda, in favor of Motilal. And therefore, our name also should be recorded because we are the children of Surendas. That could have been done by them.
Yes.
But they, why I am specifying this? Because Under regulation 204, there is a bar. 204, you know, Supreme Times. No suit or other proceeding shall, unless otherwise expressly provided in this regulation, lie or be instituted in any civil court with respect to any matter arising under and provided or by this regulation. 204.
No suit or other proceedings. Hmm.
So there was a remedy with them. Time limit was fixed.
Hmm.
They did not avail them. So all these things were required to be considered by both the trial court judge. And I'm not reading the trial court judgment and the district court judgment, Your Lordship, but Your Lordship can very well find nowhere. They can very well show it, Your Lordship, if there is anything, any adjudication on the point of limitation or outstanding. It's not that I cannot take the point of limitation or outstanding. It's not that. The law does not say so. So far as owners are concerned, I have a right to take the point of outstanding.
Hmm.
I have taken the point of outstanding not in the exact word, but the averments are there, pleadings are there to that effect.
ठीक है,
So it should have been adjudicated. This is my submission.
yes, sir. You are appearing on behalf of all the respondents.
Only one respondent I want to defend. My first assumption, Your Lordship, we are bound to go through the question framed by this honorable court while appeal was admitted. The appeal was admitted only on the one ground, page 173.
Substantial question of it.
Substantial question. Have the trial court and appeal are in law in disposing the suit and appeal respectively without taking into consideration the issue of limitations raised by the appeal both the suit and appeal. This was the only question formulated when the appeal was admitted by the court. So we are bound by that judgment passed by the revision bench to remain in that periphery of the. First of all, Your Lordship, I will refer, because this point was raised. So kindly come to the judgment passed by the trial court.
So have you taken your lunch, sir? Take lunch and come back at 2:30 or 2:45. Okay. I accommodated you yesterday, so you should accommodate us. Okay. Hey, after 2:45. We have waited for all of you.
To any matter, my lord, what happened, my lord? 230 specially fixed matter, my lord has raised.
Yes.
230 first matter, my matter specially fixed
Okay.
matter. And my lord has fixed all other matter today.
So,
My only request is, my lord, let it be on Monday.
No, there are Monday, there are so many matters.
Tuesday, my lord.
Tuesdays also.
Wednesday, my lord, any day, my lord, because today,
But I have given you so much time, not today, from.
my lord, I am arguing before the court number 1 up to 4:30 daily.
Oh.
Today also I have matter, my lord, I will 230 first matter, specially fixed matter, that will be taken.
So you are the petitioner in the.
Petitioner, my lord, in all the cases.
So what can be done?
My lord,
Any day, but then again,
my lord, all the matter, then I will be there, it will be embarrassed, my lord.
no, we have already called you, but you are not
No, I
there.
wasn't that good, my lord.
Okay.
Now my lord has raised and 2:30 it will be. My matter was called in.
Okay. Come back on Monday.
My lord.
এই ওইগুলো মানডেতে রেখে দিন যেগুলো পাসওয়ার্ড হয়েছে ওকে 2:45 Yes. Yes. Substantial question of law. Only substantial question of this.
Same on the point of limitation. So we are bound by the order of the magistrate from which the appeal was. Having. Now I will show that limitation points. Because as alleged that neither trial court nor the other courts taken into consideration of the second part.
According to you, they have discussed.
Discussed and decided.
The last portion of the judgment.
That is page 132, Lordship, of the trial court judgment. Plaintiff has stated in the page that last prosecution arose in the month of October 2000 when different order applied for mediation of the suit in October. The suit was filed on 18/12/2020. Therefore, I hold that suit is not barred by limitation. In case of partition, the possession of the sharer is to be considered as possession of the other co-sharer. Because if the admitted position hearing that we are the children of Surendas, and property was belongs to Surendas. So by way of inheritance, everybody will get the share. His legal years were 7 in numbers. So daughters and sons, and as per this, the last portion of the order, Your Lordship. So it can be said that both parties are possessing the suit land in the Ijmali. The suit property has not been partitioned till now, therefore I hold the plaintiff are entitled to get a trade for. I also hold that suit is maintainable in present form and plaintiffs have further action to file this. Last portion, the 7th share was declared by the court to be done in terms of the cumulative. Then appeal court order, Your Lordship. First appeal court order. Page 153.
153.
153 decision with reasons. From bottom to about 10 lines. The learned advocate for the appellant also submitted the suit is hopelessly barred by limitation and learned trial court failed to deal with the relevant thing. For last 30 years, there is provision and full enjoyment of the Mukti law. So this was the raised by him and the appeal court found that the learned trial court discussed all these things. In the judgment, so nothing wrong was on page because section 84, 85 and 204 and 7 was also discussed. Raised page 5 may come finally. Page 5, paragraph 2. Page 154, internal page 5 of the appellate. Letting the argument on behalf of the appellate goes to show that the trial court has good jurisdiction to entertain the suit at its guard under section 87, 88 and 204 of the regulation. But facts remain that the suit was instituted by some of the legal heirs of the deceased Surendas, actually who was the outside owner of the land, in dispute against some of the legal heirs seeking relief for party. So the London trial court is every jurisdiction to try the suit and same is not at all barred by any law for the time in court expressly or impliedly. So the written argument with regards to bar of jurisdiction has no leg to stand. The suit is well within maintainability. So there are points of law, acquiescence, waiver, and everything has been done in the accordance with law. In every law, it is maintainable and not barred by limitation. Now I will come to Lordship. Thereafter, I will refer the document. First of all, regulation 130 of this 1966.
113.
130.
Yes.
Presumption as to the
Entries.
Entries. All entries in the record of right prepared in accordance with the provision of this chapter shall be presumed to be correct until quantity is proved, and all the decisions under this chapter in cases of dispute shall, subject to the adjudication of right by a civil court, having the jurisdiction be binding upon all the revenue courts in respect of the subject matter of such dispute. So mutation does not confer any right, only have power to decide the suit in respect of the partition of the property, because revenue authority has given limited power for subdivision and partition of the property. It is decided by this revenue court, the division bench, that if one of the person who share is not agree for partition, revenue authority cannot subdivide the party of property, because they have no jurisdiction. So I will provide a copy of judgment, that division by judgment is there to the effect. So suit is there because there is 8.204. So I am referring 113 of the regulation. Suit itself is maintainable for partition before the court, and both the courts held that the suit is maintainable for partition. Now, Your Lordship, I will come to because section 84, 85, they have referred all these things. 148 of the said regulation.
148.
148. Devolution. Subject to personal law,
Hmm.
interest of a tenant in his holding on his death passed by inheritance, survivorship, or bequest as the case may be. Because personal law is made applicable to the parties if they are applying mutation, if they are Muslim under the Muslim law. 48, they will be mutation as per that. If they are Hindu, they are governed by that law. So as per this section, inheritance is there. We are claiming the property on the basis of the inheritance. Because there is no limitation for partition of the suit. When it is inheritance, every portion has every right in every portion of the land. Question of relinquish of a right, that is not there. The Lordship rightly first day he pointed out that for making any relinquishment, any document is required to that effect. Even submitting an affidavit before the imputation authority, or submitting an application, or not participating in the proceeding is not immaterial, because we have to, if we are relinquish our right, a deed is to be registered before the sub-registrar in accordance with law by relinquishing their right. But there is no deed has come before this court to show that we relinquish our right or we waive our right, because we are claiming the property. Question of waiving of right also does not arise. And that now I will come to Your Lordship to the one of the documents which was the revenue authority produced, page 121. It was not on their law, because they summoned the mutation proceeding to show that we have submitted no objection and all these things. During the mutation proceeding of 85, and property was mutated in the name of Motilal.
Page number, page number.
Page 121.
131.
121.
121. Yes.
This letter was produced by the revenue authority. So it was addressed to the government leader in connection with the same suit. With reference to title suit number 49 of 2011, Satyavan Das versus Shefali Das, the Honorable Court of Civil Justice Senior Division Court there, I am to say that neither revenue case was instituted for nor proceeding was recorded in respect of mutation of the property, as it was practiced at that time, but mutation was allowed after observing all the forward properties as per the provision of 84, 85 of the said regulation. Only order was passed by the Tahsildar on application, whereas the procedure is that on receipt of the application of mutation as per section 84, the regulation 84, he has to issue form J, he has to issue form K, he has to initiate the proceeding, and under regulation 84, he has to pass an order. If any objection has come, no objection come, but there is no record has been produced before the court, because they said there was no procedure, no proceeding was initiated. So on what basis property was mutated in his name? That is, their documents, on their behalf it was agreed.
Basis of recording. Basis of recording is missing. Basis of recording mutation.
See, whether we give an objection, whether we relinquish our right, whether any deed was executed, the proceeding is missing, nothing has come before the court.
So, now at that time, record has been recorded in the name of Motilal, but after his death, when his son is going to record mutate
Yes.
his or her name, then the problem arises. You are raising objection. That is the. Hmm.
No, no, as I also submitted the last question also, and also aware that mutation does not confer any right title. Because inheritance is the main thing, or any deed is there to that effect by transferring the right interest title in favor of any person. Giving objection, no objection, or mutation in the, it is
So-
immaterial.
So you are saying that the basis of recording the name of Motilal Das
Yes,
is missing.
is missing. The records are missing to that, as per their own documents.
But at that time, notices were issued upon you, but you did not raise any objection.
The document has not come, I raise objection or not raise objection. The document is not there,
Or the not there.
not there. That's not the page 121. Page 121.
Yes.
The revenue authority is saying no document is available.
That's
And there was no procedure to only order has to pass for mutation.
hmm.
Assuming for argument's sake, I participated in the proceeding, notice were issued to me, I have raised objection or given no objection, the document must have come before the court.
Hmm.
And as per the schedule of property, like kindly, they are showing one power of attorney. That in respect of power of attorney was given to this Satyavan Das. That power of attorney was given to sell a particular survey number. To sell him, why he will give power to sell him? That person. The power of attorney is really shown by the other side.
Special power of attorney.
Yes.
Special power of attorney.
Special power to sell his property and to convert it only one survey number 381. Whereas the schedule of property, there are numbers of survey numbers. Kindly come to page 14. You see, they are in respect of one survey number, they are showing this. Page 14 is the schedule of property. There are three schedule of property A, B, C. And they are saying in respect of schedule C property.
Hmm.
The power of attorney was given in respect of that. But power of attorney was not for any other purpose, was to sell that property. But he has, my client who is the Satyavan Das plaintiff, he never sold the property. No the power given by him to sold that property.
So power of
The numbers of properties are there.
was given to sell some property.
Yes, sir, to that power of attorney they mentioned, I will show the document. Yes. That is, we start from page 98. page 98, in the cost writing. The special property, page 99. What was the power given and in respect of which survey? Only 381 survey number is mentioned there. You have it in the top to the first paragraph, last line. Then there is survey number 381, comprising and holding number such and power was given to appear before any court such as civil, criminal, revenue, government department, office and to discharge the necessary in connection with the dispute pertaining to the above level to apply for authority for granting occupancy right and also necessary for granting the same permission of the above landed property to make payment of the land rent premium, fine, etc. to the government time to time and also to receive the document and also to receive no demand certificate. Next, to put the tenant on the said landed property, to put the tenant on the said landed to the said rent or profit with the tenants and also to keep the said landed property under his physical possession, control and enjoyment of the said property. To undertake any kind of construction work, building and any found well within the said landed property at the cost of attorney and also to do things necessary for the purpose of development and improvement of the said property, to sell out the said property to any other purchaser and all this. So these are the powers given. We show that this property was actually given to him by the Motilal. But this document does not show that they are saying that I am not in occupation. This document, their document, it shows that I am in occupation at least of this survey number as per this power of me to do certain acts and to even to sell that. But I did not never sell this property. So these are the things. My submission is only that limitation in favor of any person does not confer any right title interest. I will provide the citations also on that point by Monday. And the partition suit is before the revenue authority is not maintainable. And they said that the entries are correct, presumed to be correct, but 113 very clear. 113 of the LR that that is the subject to the decision of the civil court. So my submission is that neither the trial court nor the appellate court committing any wrong in the declaring the suit and dismissing the appeal. So I pray about it, this appeal should also be dismissed.
Yes.
Not what we mentioned. Yeah, just only to show that what is being said by the other side, that proceeding has not been exhibited. It is page number 106, exhibit H, where signature of all the parties are there.
Page number?
106. When Form G was issued, they signed it. (106) is Form J. 107, page number 107 contains the signature of all the parties.
Yes. But in that letter, that is the letter issued by the
Form G issued by the Tehsildar.
page 121.
Yes, that is, he's showing 121, but I had the records.
Yes, in that letter, it has also been mentioned that Form J and Form K can be produced.
And
That
Form J was produced, page
yes.
106
So
and 107.
it is true that there was mutation.
No, he's telling that proceedings has not been produced before the court. Proceedings has been produced 106 without objection. It was marked as exhibit H.
Order sheet has not been produced of the revenue case.
They are not disputing mutation. Have you
Yes.
disputed?
No mutation is
They have
disputed.
not disputed mutation.
But he is saying that mutation does not create any title.
Yes.
Okay, hey, Arun, the learned counsel for the appellant has resumed her submission and concluded the same. Stop. The learned counsel for the respondents has also concluded his submission. Reserve the judgment. The judgment is reserved 10 April. Let the matter fixed for delivery of judgment on 10 Dostcha.
We also wanted 1987 scheme.
Yes, yes. And another judicial decisions. You want to submit any decision?
I will submit decision by Monday. Two decisions.
Which did, in support of which point?
Respect of the subdivision proceeding, they say that civil court has no jurisdiction, 204 they raised the point.
As per regulation, I think.
The
No?
regulation 204. And
Okay.
another is in respect of, record of right does not confer any right, I believe.
See, it is known to everybody.
Petition does not.
It is
Different law. My point is totally different.
yes. Waiver acquisitions
Yes.
and limitation point, but no
Limitation
issue-
is one
no-
of the aspect.
no issue has been framed. But in spite of that, the matter has been taken up. Consider, discussed in a cryptic manner, but has been discussed. Whatever it may be, I shall pass necessary order. এগুলো সব গুছিয়ে দিয়ে দিন, এগুলো কিন্তু আলাদা। এটা আমাদের বই। এগুলো তো আমরা, হ্যাঁ। ঠিক আছে, এগুলো দিয়ে দিন। আর কিছু আছে? হ্যাঁ। চব্বিশ আছে।
For the limited purpose, the matters are listed for consideration by interim bail.
Yeah, interim bail or interim order,
Clear.
which for the other side.
That's the rules. Let me send my manual. They are privileged to file opposition. That
Yes.
is taken care of, a lot of granted time. But so far as interim protection is concerned, but I am occupying the land in my.
No, in that case, we passed an order, oral order. But after finding that there is no interim order, then we did not.
Yes, yesterday my lord passed certain orders in this. They have
This-
sought for time to file opposition, that was granted. But my lord has fixed the matter for consideration of interim bail. Yes, my lord passed yesterday. On that day, it was my mistake. I said that.
No, we shall give them time to file their written affidavit in opposition.
My lord.
Now, what is the prayer? Your prayer?
Lord, I am having.
You have no objections.
Lord, I am having a property in my name.
Hmm.
I have raised building by obtaining building plan.
Hmm.
A busybody who is an adjacent court holder lodged a complaint. It rolled up, finally an eviction order was passed at the first instance. That was challenged before this court. It was set aside. The matter was remanded back to the Tahsildar. Tahsildar again passed the same order. Violation of principle of natural justice are there. Adverse materials were used against me, that was not given, God knows it. Any adverse material which is issued against an eviction, issued against the person who would be suffering an eviction order, he or she must be given an opportunity of hearing. Report has to be supplied, I have a right to liberty, then order needs to be passed. That's one of the grounds. Secondly, since I am in possession of my building, because by virtue of the eviction order, my building will be demolished.
No, yes. Why is the order?
I'll just.
Page 40, last page 44, I think, 44.
44 is the electricity bill.
They are very.
This Sabab Hussain.
Yes, Sabah.
What is the order?
Order is dated March 21 to 2025. Annexure. And this.
Madam, 94, page 94. Order
94. This is the order in which I have challenged. What is paragraph second?
Just read. Yes, paragraph second.
Of the interim order at page 94, Malad to see that there is a joint inspection was conducted on 21/20/25 by the revenue officials, including the revenue inspector to Patwari surveyor and JE of municipal council to demarcate the land bearing survey number 1069 situated in Chandigarh. And whereas as per the review for the land bearing survey 1069 situated in Chandigarh as recorded as far. As per demarcation report, an area of 18 square meter of survey number 1069 which is recorded as road is under physical possession of Sajad Mission and two others. And whereas an opposition was given, they say not was not done so. Finally, penultimate paragraph. Now, therefore, you are hereby directed to vacate, remove the unauthorized occupation upon a government revenue land bearing survey number 1069 of Chandigarh on or before so claiming with the same will be removed by the review authority. But this order came to be passed pursuant to a direction of this court passed earlier. Same order was passed. Again, they did the same mistake. This report Lord knows it. If something is used against me, if I'm going to suffer an eviction order, as per law, audio ultimatum partem demands that I have to be given reports during course of hearing so that I can rebut. Then a decision has to be taken based on my argument. My argument has to be recorded, consideration has to be turned on. But these are the basic principle of law, decision making process. That was not followed. And what I am the recorder of a land, adjacent land, a building is standing there. Now they say that I am an encroacher.
No, whether eviction process was taken. Eviction.
The matter is pending before this honorable court, so not here.
So
It's on third March, but
he's praying for interim order. So I think it should be passed for a limited period. Yes. Okay. The learned counsel. Huh?
that the authorities have not filed their opposition.
Whatever it may be, the learned
So this-
The learned counsel for the petitioner has submitted that the order dated. What is the date of the order?
It's 21 to 2025. Signature Malad to find the date.
21 hand.
21 to 2020.
Order dated 21/2/2005. কি বললাম?
The learned counsel for the petition has submitted that the order dated 21 to 2025
Is not sustainable in the eye of law, as the petitioner was not given sufficient opportunity to place his case before the.
You know, if my lord sees page 91.
Okay, I shall record your submission also.
Page
Before
91.
the learned before the Tehsildar Sri Vijayapuram. Stop. Moreover, the direction of this court no, the order dated 8th February 2024 of this court has not been complied with by the Tehsildar Sri Vijayapuram in passing the above referred of order dated 21/2/2025. Stop. By the said order, the petitioner has been directed to vacate, remove the unauthorized occupation upon the government revenue land bearing survey number 1069 of Jangli Ghat village on or before 28/2/2025, failing which the same will be removed by the revenue authority on 3/3/2025. Stop. Para. the learned counsel, Mr. Joypal, has submitted if an interim order is not passed restraining the government authority, the petitioner will suffer irreparable loss and injury. Stop. He has further submitted that the principle of odi atem partem has not been followed by the concerned officer before passing the said order dated 21/2/2025. Stop. Para, the learned counsel appearing for the respondents. Respondent number 1. Respondents has vehemently opposed the prayer. She has drawn our attention. She has drawn the attention of this court to the relevant portion of the annexures showing that due notices were served upon the petitioner. And another thing,
91, 90.
there are three petitions. Petitioners. There are
Yes.
three
Give me the
petitioners.
number, one after another, which is
Stop.
And what
Till-
is this one? 91, page 91.
Yes. 91 is in respect of one accused. Sorry, yes, page 93. Same notice. Oh. So she has also mentioned that at least two occasions, or at least two occasions, petitioner was notified about the hearing of the matter before the Tehsildar Port Blair. Stop. Therefore, it cannot be said that the petitioner was not given sufficient opportunity to place his case. Stop. Para. However, I have considered the materials on record. It appears that an order of eviction has been passed against the petitioner. Stop. The petitioner has legal right to challenge such order in the legal forum, and accordingly he should be given an opportunity to place his case before this court. Otherwise, there is a chance of causing irreparable loss and injury to the petitioner. Stop. Para. In view of the above, I direct let the order dated 21/2/2025 be stayed till 36/2025 or until further order, whichever is earlier. Stop. Para. The respondents are at liberty to file their affidavit in opposition within 4 weeks from date, affidavit in reply, if any, be filed 2 weeks thereafter. List the matter on the second day of the next circuit in the month of June 2025. Parties are given liberty to communicate this order to the concerned authority.
Same order in other two.
Okay, name,
Same, name. But this judgment of probate. has been
yes, thank you.
By Justice.
Alok Kumar
Yes,
Chakraborty,
yes, yes.
Kumud Ranjan Kaur.
No, that is Alok Chakraborty and Malay Kumar Basu.
Ah.
The case of same, Meena Devi and sister, same with proposition.
Oh, good. Thank you. Thank you very much. Well, it has been reported or?
Yes, ILR. One is order sheet, fellowship, the other, that was reported in ILR, and given that was.
Okay, complete. হ্যাঁ তিনটে হবে নাম চেঞ্জ হবে ওকে
Right.